In family law settings, people, we have seen and experienced, people have used or set off the meher amount towards the spousal support obligation. But am I correct to say that spousal support is different than the COPR financial undertaking?
Absolutely. These are absolutely two different things.
Can a PR holder sponsor a new spouse immediately after the divorce?
Yes, they may. They cannot be married before the divorce. They can be in a common law relationship before they get divorced, but the application for sponsorship can only be submitted after the divorce has been finalized.
There is a lot of confusion between people that, oh, I don't want to disclose my financial disclosure, and why do I need to? I've already discussed it with my partner that I don't need to put it down to form part of that agreement. What legal protections exist for spouses in an arranged marriage that leads to abuse?
Something like this, who's going through abuse, please do not stay in that relationship just because you fear what will happen to your immigration status. Stand up for yourself, speak up. There is support available for you, to you, so make use of it. Do not stay in that relationship of abuse just because you fear your immigration status. Hello everyone, we are back again to answer some very, very important questions that are related to immigration and family law. Today with me, I have Monika Goyal, a very renowned and successful family lawyer from the Monika Goyal law firm. We both together are going to answer some questions for you. Monika is going to ask me some questions about immigration and how they affect spouses in Canada, whether they're Canadians, permanent residents, and then I might also ask some questions to Monika. Monika, are you ready?
Yes, absolutely. Thank you for bringing me on board again.
No, it's an absolute pleasure. And yeah, let's do this.
Perfect. Just like you said in our last meeting that you get a lot of clients who ask you questions about family law, we get so many clients who would ask us questions about how does immigration work. So I have penned down few of the questions for you. Maybe you can answer those questions for our clients. So Shifali, what legal steps should immigrants take when getting married in Canada?
Okay, beautiful. That's a lovely question. A lot of my clients ask that question as well. So first and foremost, if you are somebody who is on a temporary resident status in Canada, or even if you're a Canadian citizen, regardless of your status, the first step that you need to do is you need to go to the local service, Ontario or whatever province you are from. We're in Ontario, so I'm going to use Ontario as a reference. So Service Ontario's office, marriage licenses and marriages are regulated by the province. So you go to the province's office. So you go to Service Ontario and you get a marriage license. Once you have obtained a marriage license, that is when you then book a date for your wedding. You usually get a 30-day window between which you could get married. You can then call the city hall, or you can call a marriage officiant. You can book your wedding date and you get married on that specific date that you've booked. Once you're married, the marriage officiant will usually will do the paperwork for your marriage registration. In Ontario, it takes anywhere between 8 to 10 weeks for a marriage to get registered. You could request to get the marriage registration expedited, but then again, that's up to the marriage officiant and how fast they can do it for you. Once your marriage is registered, after that you apply for a marriage certificate. This can be done online on Service Ontario's website or your province's specific website. And once you apply for your marriage certificate, you could pay additional fee to get the marriage certificate delivered to you sooner. That could also be done within 3 days. Usually if you don't pay for the expedition fee, if you don't get it expedited, then it could take about a week to 2 weeks to receive your marriage certificate in the mail. Don't forget, for any immigration process, you must have a marriage certificate with you. Just the fact that you've done a marriage and then you have the record of solemnization is not a sufficient document for your PR application.
Okay, that's perfect. So we know now that the parties after receiving their marriage certificate are legally married. What about those who does not have any legal status, or the parents who want to enroll their children into the schools in Ontario? How does that work?
That's a very, very interesting question, and I've actually faced some of my, I've faced this situation in the past with some of my clients who did not have a status, and they had young children who had to go to school. Monica, in Ontario, it is a law. Every child has the right to education. So usually schools cannot deny admission to children to schools. But there have been cases where children have been denied. That, because you don't have a status, you can't get, the child cannot go to school. In that case, what parents usually do is they would go to the school board, they would sometimes use the help of the MPs or MPPs involved and get the admission done. But, if I talk on humanitarian grounds, every child has right to education. And if the parents are here and they don't have a status for whatever reason, in majority cases, children are not denied the right to education. They should be given that right up until they're here. Once the parents are deported or they're sent back, then it's a different situation. Then obviously the child goes back with them. But as long as the child is living in Canada, the child should get education. But again, it's case to case. Sometimes you have to flex your muscles. Sometimes you have to go to higher authorities. It's not as straightforward. But yeah. That's the answer.
Thank you. Perfect. So does that mean that a non-status parent's child would be considered a foreign national, so to speak, for the school purposes?
Absolutely. Now, it completely depends, right? Sometimes even out of status people have Canadian-born children. Now, if the child is Canadian-born, then there's no problem at all. The child can go to school, no problem, because they have a status in the country. But if the child's parents are out of status and the child was not born in Canada, then obviously the child also does not have a status, and they're considered out of status foreign nationals in Canada.
Perfect. So we have talked about parents who are legally married in Canada. We've talked about parents who do not have any legal status, but they want to enroll their children into the schools. Now, what about those who have some protection as refugees to become permanent residents? What about those people?
So this is amazing, right? And now let's say, I'm just going to ask for a clarification. Did you mean in context to the children, or in general those individuals who have those protections in Canada?
We will talk about in general, like what happens to the refugees or the people who are out of status or who have a refugee status to obtain their permanent residency. What happens to those? Okay,
beautiful. So, refugees can be put into two categories. There are refugee claimants, and then there are protected persons. A person who's a refugee claimant has no status in Canada because they're just somebody who has claimed a refugee status in Canada, but their claim has not been approved yet. So they're in a limbo at that time. So they're people without a status in Canada. But once those people have been approved of their claim, so if the Immigration and the Refugee Department, or IRB as we call it, Immigration and Refugee Board, and particularly Refugee Protection Division, if they approve their claim, in that case they become protected persons in Canada, and protected persons have all the same rights as permanent residents, because once they're protected, then they can apply for permanent residence in Canada and get their PR status. And it would be the same way for the children. If they're in Canada, the children can also get the same rights as the parents. So, but if you're a refugee claimant, then no, you don't have the same rights. But if you're a refugee, but another thing to bring here, if you're a refugee claimant, you are still granted a work permit. That work permit does not grant you a legal status in Canada, but it allows you to work in Canada. And the family of those people who are already in Canada, so let's say if they have young children, can also get student work, study permits in Canada to study in school. So refugee claimants' children can go to school, but again, that does not mean that they have a legal status in Canada, but they're authorized to study and work.
Perfect. Again, I think there are a lot of people who do not have right guidance, who do not have proper information, and they lack this guidance. They lack somebody who is qualified and expert to talk about their immigration needs. So I think this is a great platform for all of those to get some more information about how can they obtain their permanent residency status in Canada.
Absolutely,
so, absolutely. Thank you so much for that. Now this brings me to another question. Can a person without status marry a Canadian citizen and apply for their permanent residency?
Yes, absolutely they can. So I think this is the only program in Canada. I mean, there are other programs like humanitarian and the refugee, but a legal way to get sponsorship in Canada, and the most straightforward way is if there is a person who's out of status and they do get married to a Canadian citizen or a permanent resident, and if their marriage is genuine or their relationship is genuine, then they can apply for permanent residence in Canada. They are permitted to do so even without status.
Perfect. Now, see, we have a lot of follow-up questions. This brings me to another question. Can a foreign divorce be recognized in Canada? And I think from an immigration perspective, you can, because you are an expert in immigration, so maybe you can answer this question from a legal immigration perspective. And then, yeah, so tell me if a foreign divorce can be recognized in Canada.
Yes, absolutely. Majority of the foreign divorces are recognized in Canada for immigration purposes, except for the khula from in the Muslim culture. Khula is not accepted by Canadian government under immigration or for immigration purposes. So if you are somebody who obtained a khula and you have the certificate, a khula certificate, then that will not be recognized. You will actually have to get an actual divorce completed from your local jurisdiction, or you can initiate a divorce here in Canada, even if your partner is not here. But other than that, majority of the divorces that have been legally obtained in their particular jurisdictions or their countries where they're from, they are accepted in Canadian immigration for Canadian immigration purposes. Every country has their own set of rules, so make sure that when you're applying for your permanent residence, you go through the document requirements, and usually IRCC is very, very clear and specific about the particular document that they need for the divorce certificates. I'll give you an example. For example, some of the divorces from India, IRCC specifically requires the divorce decree, the divorce petition, and then also the divorce judgment. So all these three documents have to be put together and submitted when you're submitting your application.
This is interesting because in family law, it's not completely different than what you have advised us today and what you have guided us through for the immigration purposes. In family law, we do accept every kind of divorce that has happened, that has a legal standing. For the family law purposes, we do accept those divorces, and that is a valid divorce, so to speak, for the purposes of obtaining a divorce order or for the purposes of the courts to intervene in Canada.
Oh, that's very interesting. So does that mean that under family law, khula would also be considered acceptable?
Interesting, and it's not the term that we are using here. So like you said, as long as the parties have a decree, as long as the parties have a court order, sometimes we talk about civil marriages, sometimes we talk about religious marriages. As long as the parties are able to prove, and it is uncontested for family law purposes, it is considered valid for the Canadian courts.
Amazing. Very, very interesting to learn.
Now, another question that I'm positive we both can answer for our respective clients, and obviously there are clients that are seeking help in the family law, in their family law matters, as well as the immigration issues they have. So can a spouse refuse to cooperate with a divorce to impact others' immigration status?
Yeah, then that happens more often than we can even think of. You know, sometimes people just turn hostile. Sometimes they don't take the whole divorce process in a very positive way. And it can be heartbreaking and it can be very difficult. But unfortunately, if your partner is not cooperating, it can impact your PR application and especially right now, these days that we've been noticing, IRCC is very, very, very particular about documentation. So if you've mentioned in your application that you are somebody who's separated in Canada, IRCC will ask you to prove that you're getting divorced. If you've said that you're divorced, then IRCC will ask you for divorce documents. If your partner is not cooperating, then you could face issues in getting your permanent residence approved, because let's assume that even if you were to mention at that point that you're married, because let's say you want to avoid all the hassle, and then you say, okay, just because I'm not legally divorced right now, I am married, for that purpose, in that particular scenario, then IRCC will expect you to submit your spouse's documentation, such as their medicals and their police clearance and their passport. And we've seen sometimes that in divorce cases, if the partner is not willing to give a divorce, they're also not willing to provide other supporting documents to support their partner's PR. So this can be more complicated than we think it is. But yeah, if the other partner is not cooperating, it can create problems in your PR application.
Absolutely, and this is what we see every day, every time when we are in a family court, that if one spouse, if one partner does not cooperate, it does affect obviously their family law matters and their immigration statuses. So thank you again for answering this question. This leads me to another question. Can a person sponsor a new spouse if they were previously married or divorced?
Yes, they can. There are certain sponsorship restrictions. If this person was sponsored by somebody themselves, then they cannot sponsor a new. So if they were sponsored by their spouse, then and they divorced that spouse, then they cannot sponsor a new spouse for at least 5 years. There's a ban on them for 5 years sponsorship. But if they came to Canada through an economic sponsorship, let's say the applicant or the sponsor and their partner, they came to Canada under one of the economic programs, and then they came to Canada and got divorced, the sponsor can now sponsor their new partner. There's no restrictions, there's no timeline, but only and only if they've been sponsored previously through another spouse, then there's a restriction on the timeline. Like they can only sponsor another spouse after 5 years.
This is interesting, and this is new to me. So again, thank you for this knowledge and sharing your expertise and all the experience that you have gained throughout these years. So thank you so much for that.
It's an absolute.
Okay, so if a marriage is considered fraudulent, what are the immigration consequences?
Okay, so it depends on when IRCC will find out that the marriage is fraudulent. If they find out during the processing of the application, there are very serious consequences. The applicant can be banned for misrepresentation, and they cannot apply again for any program in Canada for 5 years. Now that's while the application is in process. But once the application is approved and the person has landed in Canada, become a permanent resident, then unfortunately there's not much that IRCC does. I don't know how things will evolve going forward. Maybe IRCC will start interfering in this process a little bit more. But as of right now, as we know, as we speak, once the person has landed, and if IRCC finds out later that the marriage was fraudulent, there is very less chances for them to revoke the PR. It doesn't work like that.
Absolutely, and there are a lot of clients of mine, clients who are seeking family law help. New immigrants, to be specific, they would ask me that I want to revoke my partner's permanent residency, and how can I do that? So my answer to those, as like you've mentioned, you cannot revoke their permanent residency status even if you are divorced, even if you are separated. However, like you said, if IRCC finds out that your marriage was fraudulent, then they can take further steps and investigate, and there are severe consequences for that, right?
Also, another thing I'd like to add, and I can probably share an experience in this particular scenario. I had a client who sponsored their spouse from back home, and before the partner actually landed in Canada, so you are not, even if your PR is approved, you're not a permanent resident until you've landed in Canada, until you finished or completed your landing formalities. So this client of mine, they got married, they sponsored their spouse, the PR was approved, but the spouse had not landed in Canada. So she had not arrived in Canada yet. And things, didn't work out. The marriage fell apart, and the sponsor wanted to actually withdraw the application. Luckily, in this particular case, we could ask for IRCC to withdraw the application or cancel the permanent residence for the applicant, because the applicant had not landed in Canada as a permanent resident. They were still outside Canada. So in such a case, it is possible, but had this applicant landed in Canada already and had obtained their permanent resident status, there was no way for IRCC to revoke that PR at that point. Marriages can fall out. It is a part of life. We just got to accept it and move forward.
Absolutely. And as soon as we understand, as soon as we accept this truth that we need to move forward. Life becomes easier for all of us.
Absolutely.
Perfect.
Absolutely.
Now, let's talk about the financial responsibilities. Does a person who has sponsored you, who is your sponsor, have any financial responsibilities?
Absolutely.
Okay.
If you're sponsoring your spouse, you are financially responsible for them for 3 years from the date the PR application was submitted. Not from the date the PR was approved, but from the date the PR application was submitted. You sign a financial undertaking. There is a form that you sign as a sponsor that you promise, in simple words, to take care of all their financial needs for 3 years from the date of the sponsorship.
Interesting, very interesting. I want to talk to you about a specific case where I was retained as a family lawyer, and there was a client who who is originally from Pakistan. He sponsored his spouse, and the spouse came over to Canada. And at the time of entry, when the spouse was getting her confirmation of permanent residency, it is written on the piece of document that the spouse is financially responsible for her for 3 years, and in the event she's seeking any social assistance, the spouse who has sponsored her would be responsible financially. How does that work?
Yeah. So, like I said, that if they sign an undertaking when they sponsor the applicant or their partner from back home, or if they're already living here, and they are financially responsible for them for 3 years. Now, if in this period the dependent spouse, so the spouse, actually applies for social assistance or welfare, then the sponsor is responsible to pay back. It is called an immigration loan. So they will have to pay back. They cannot sponsor another spouse or anybody else until that immigration loan has been paid back. So absolutely, they're responsible for it.
Okay, interesting, because I was looking for an immigration expert to answer this question for me, since I do not have any knowledge and expertise in what you do. So now in this case, because my client has paid meher, which is a contract, the parties sign a contract at the time of marriage that he will be financially responsible. There is a sum of amount that he has undertaken to pay her at the time of rukhsati, so to speak. Now, can he write off, or can we consider meher against the financial responsibility that he has under the COPR?
No, that is completely different. I think for the family law purpose, maybe you can use it. Again, I wouldn't know too much about it, but I think for family law purposes, you can, in the final settlement for them, you could still use that as an amount that, or maybe they could do like a separation agreement wherein both the parties agree that the immigration loan will be paid from this amount. But if the applicant or the partner actually did go on welfare and there is an outstanding immigration loan on the sponsor, then the sponsor is obligated to pay that. Now, under family law, I don't know how the terms are negotiated, and if there is a negotiation or there is something on the table which talks about that they are going to pay off the immigration loan, the sponsorship loan through the meher amount or whatever the parties agree to, then yes, that is possible, but there will be an immigration loan outstanding in the name of the sponsor if the applicant does go on welfare between these 3 years.
Interesting. And for clarity for our audience, in family law settings, we have seen and experienced, people have used or set off the meher amount towards the spousal support obligation. But am I correct to say that spousal support is different than the COPR financial undertaking?
Absolutely. These are absolutely two different things. Again, we have to understand the immigration loan is only it only comes into play if the applicant actually goes on welfare. So let's assume your client does not go on welfare at all. So if she doesn't go on welfare, then there's no immigration loan. So when I say social assistance, means she applies to the government for social benefits, like that she doesn't have money to eat, to she needs, for basic necessities, she needs the money. So that's called welfare amount. If that's what she takes, that's when there will be an immigration loan against the the sponsor. But if she doesn't go on it, then there's no immigration loan. Then everything else is I think on the side of the immigration law.
This is very
the
interesting.
family law.
This is again very interesting. But I think we need to talk further about this, because a lot of people here think that once you have a financial obligation to support your the person that you have sponsored to come to Canada, they are financially responsible for 3 years, which means that they have to provide for the basic livelihood, shelter, food, and etc.
Which is true, and you would go on welfare only if you cannot get those needs met by your partner. So if your sponsor is not fulfilling those needs for you, is not giving you shelter, is not giving you the food, is not giving you your basic necessities, and you don't have the ability to earn, then you go on social welfare.
Absolutely.
Right? But then let's assume there's somebody who doesn't go on social welfare because they have a job for themselves. And social welfare is not also available. If you're working, then obviously how do you apply for social welfare? You can't do that because you're earning, right? So if you're educated and if you're earning, then you don't need to go on social welfare. In that case, the sponsor's off the hook. The sponsor doesn't.
And does that automatically, you take it off automatically after the expiry date? How does that work? Do they need to apply to get off the COPR financial obligation?
No, after 3 years, it's automatically done from the date that they've applied for the permanent residence for their partner.
Perfect. So they don't need to take any further additional steps?
No. Automatically it's done.
Okay.
And then
perfect.
if ever they have to do another sponsorship, the IRCC officer will check whether there's any restriction on them or not, and if not, then.
Perfect. So another question that from this interesting conversation: can a PR holder sponsor a new spouse immediately after the divorce?
Yes, they may. They cannot be married before the divorce. They can be in a common law relationship before they get divorced, but the application for sponsorship can only be submitted after the divorce has been finalized.
Perfect. Now, you mentioned common law spouses. How does that work in immigration? How can is it different than being married? Is it different than you have a child together? How does common law works in immigration world?
So common law partners are considered just like married couples. The definition of common law under immigration is that if you've cohabitated together for consecutive 12 months, there can be short breaks in between, like, if there are minor trips here and there. But if you've cohabited together for consecutive 12 months, then you're considered as a common law partner. You should be living together as a married couple, sharing all the responsibilities, your finances, your expenses, and all of that. Of course, minus the marriage certificate, but everything else, just like a married couple, you're considered as a common law. You're considered as common law partners, and then your partner can do a sponsorship application for you.
So is it correct to say that if a common law spouse wants to, or a common law partner wants to sponsor their partner to come to Canada, they don't require a certificate, they don't require a decree or a judgment that they are a common law partners?
So, it's very funny that common law, you have to be living in Canada in majority cases, because if you're not living together, how are you common law? Now, if you're not living together, but you've lived together at some point in the past and you've proof, then yes, you can do that, but that's in rare cases, and if that happened, then you must have this is complicated, and there's too much that we have to go back and forth on this. But if you're a common law, you should, and before you came to Canada, then you should have declared your common law partner in your PR application when you submitted it. Because if you never declared your common law partner when you did your application, then that's complicated. But in majority cases, usually common laws are when they're already inside Canada, most cases. Now, there's also another category of sponsorship called as conjugal partners, wherein you can't live together because of certain restrictions in your home country, or there's, for example, if you're a same-sex couple, you can't be living together, but you do have a relationship. You can't be living together because that country where your partner is living doesn't allow that, and the partner cannot come to Canada because they don't have a temporary residence or they don't have a way to come to Canada. In that case, you're considered as conjugal partners. Sometimes I'll give you another example. I had a couple from the Philippines. Philippines has a specific law of annulment of marriage. Even if you get divorced anywhere else in the world, you cannot be considered divorced in Philippines under certain conditions, you know. So you have to get your wedding annulled in the Philippines for your marriage to actually be dissolved. So I had a couple that the sponsor was living in Canada, and the partner was back home in the Philippines, and because the partner here was already married and he got the divorce in Canada, but he couldn't go back and marry that girl in the Philippines because his marriage was not annulled in the Philippines, and his partner here was not cooperative to go back to the Philippines to annul the marriage. So in that case, we did a conjugal partnership wherein we proved that they both have a relationship. They've been spending time together, they travel to each other, but they can't live together because she's in the Philippines, he has a job here, he has a life here, so he can do back and forth. And we were successful in getting the partner here as a conjugal partner.
Excellent, and I want to congratulate you on that. So what do you think about, so if you are filing for an application, for a permanent residence application, and the parties have a marriage contract or a prenup agreement, how does that work?
This is something that I've not heard. In immigration, we have nothing to do with prenups. I think, again, that's a family law matter. I would rather ask that question to you. How do prenups work in today's day and age? I know a lot of people run away from getting married. They're scared. But I truly think that getting a prenup is a great way forward, especially in today's day and age. Can you tell us a little bit about prenups?
Absolutely, I would love to. So basically, it's called a domestic contract. A domestic contract is protected under Section 54 of the Family Law Act. And anybody who either wants to get married, the two partners can be same-sex couples, can be different gender. If they want to get married, they would, and they want to protect their assets, if they want to protect their net worth, they would enter into a prenup agreement. So a prenup agreement, a prenuptial agreement, is an agreement where parties, when they intend to get married, they would sign on an agreement, which is also considered a marriage contract, again protected under Section 54 of the Family Law Act. If they want to protect their assets, if they want to protect the liabilities, if they want to protect their net worth, they would ask their partner to sign off to this contract, which will allow them to not share their net worth if and when the parties have a separation, if and when the parties go to court in family law settings.
That's very interesting. I do have a follow-up question on that. How easy is it to do a prenup?
It's an understanding between the two parties. Mm-hmm. If for example, and I get a lot of queries about, oh, I want to get a prenup done, I want to get a marriage contract done because I'm getting married in a month or so, and I want to protect. So basically, I want to protect my property, for example. Basically, a prenuptial agreement is for those who have some property, some assets in the province of Ontario, and they don't want their partner, the new partner, to take a share from that property, which is why they ask a lawyer to get into the marriage contract, which will protect their property, which will protect their assets.
So what happens, is it only for properties that you already hold, or is it also for any future properties that you buy?
Very interesting question. A lot after COVID-19, I'm sure there are a lot of people who were interested in investing in pre-construction. So there are pre-cons that the parties would sign up, and if and when they decide to get married, they would also include a clause to protect their in the prenuptial agreement, their properties that they do not even have possession of. So, for example, the pre-construction. For example, some properties outside jurisdiction. Some properties that, for example, our clients belong to India, our clients belong to Italy, our client is from Pakistan. They want to protect their property back home. They can also include those properties in a prenuptial agreement.
Mm-hmm. So that means both parties must do their financial disclosures way ahead in time. It's only then they'll be able to eventually get any relief.
Absolutely.
Or their prenup agreement will hold true to the law if they really want to do it. I mean, they have to do their financial disclosures up front before they even get married. Is that correct?
Yes, that is correct. But there is a lot of confusion between people that, oh, I don't want to disclose my financial disclosure. And why do I need to? I've already discussed it with my partner that I don't need to put it down to form part of that agreement. But as per the law, you have an obligation to disclose your financial statements. You have an obligation to disclose what you hold at the time of getting the prenuptial agreement or a marriage contract signed. So if you don't do that, there is a high chance that if and when your matter goes to court, the judge will set aside your agreement. And if that happens, then all of what you have done is of no use.
I agree with you.
Your property is not protected if you have not disclosed. Now, there is also an exception to the financial disclosure. People sometimes don't want to disclose it and they would sign a waiver. But again, there are consequences of not disclosing your financial disclosure.
Yeah. I would believe so too. There's no point in doing a prenup agreement if you're not disclosing all your properties and all your assets in advance, because how is it even uphold the law if nothing is disclosed up front?
Okay, interesting. Now, another question from a lot of people, I'm sure, and it's a very popular question. What legal protections exist for spouses in an arranged marriage that leads to abuse?
That's a very interesting question, especially in today's times when we have seen a significant increase in intimate partner violence and domestic violence cases across Canada, especially in the GT area. It's very unfortunate that this is happening in this country, but this is the matter of fact. IRCC, for immigration purposes, does have some relief for spouses that have been in situations of abuse. If you're somebody who's lost status, you can apply for a temporary resident permit in Canada. If you've been somebody who's been out of status and in a situation of abuse, you're also eligible to get a work permit under that TRP. If your partner had promised you that they're submitting your spousal sponsorship, or the spousal sponsorship was in process, but there has been withdrawn, there's also relief for you. You can also apply for permanent residence under humanitarian compassionate grounds if you are somebody in a situation of abuse. So if you are somebody who is going through something like this, who's going through abuse, please do not stay in that relationship just because you fear what will happen to your immigration status. Stand up for yourself, speak up. There is support available for you, to you, so make use of it. Do not stay in that relationship of abuse just because you fear your immigration status.
This is a sad reality, and a lot of people fail to understand that the fear of losing their permanent residence status, they would have to live in this relationship. They have no choice. There is no way out. They cannot move out of this abusive relationship. And from a family law perspective, I think this is what we hear every day. There are a lot of women who would come and seek assistance, who would come and seek guidance on how to escape an abusive marriage. And my message to all of those is that you just need to stand up for yourself. All you need is a little courage. If you have children, think about the children. Think about what kind of environment you are giving to your children. Think about if this is in your children's best interest to remain in this abusive marriage. So all you need to do is just speak up against this abuse and seek assistance, seek guidance from anyone that you can trust, anyone that you can believe. So, yeah.
Yeah, that's very important. I know it takes a lot of courage to walk out of a marriage, especially if you have young children involved, but I think it's better, and we've heard it time and again, it's better to have two safer homes, happier homes, rather than living in one toxic home. That's how your children will flourish. That's how your children will prosper. You'll be able to provide them a safer environment. So not moving out of your relationship, an abusive relationship, just for the sake of children is a wrong excuse. You must walk out of your abusive relationship for the sake of your children. And that brings us to the end of this video. Thank you so much, everyone, for your time, for tuning in, for listening. If you stayed till the end, thank you very much. If you have any follow-up questions, do leave your questions in the comments below, and we will try and answer them for you in our follow-up videos.
Absolutely. It was such a pleasure to be here and talk about the immigration needs for everyone who are looking for some right guidance. Shefali is there to help you.
Thank you so much, Monika.
Thank you. It is such a pleasure.